This lecture is about Sharia and Islamic law. In this lecture, we will explore what Sharia is and different ways of understanding what it is, and also what Sharia consists of, how Sharia developed, how Sharia is applied today in Muslim majority and minority contexts, such as Australia, calls for the reform of Sharia as law, and finally, how Sharia is applied by Muslims, and we'll look at the example of Australia. So, what is Sharia? What does the word Sharia mean? Well, it is an Arabic word and it actually has a number of meanings. It has a literal or linguistic meaning, as well as the many ways it is commonly understood. Let us take a look at its various meanings very briefly. The term Sharia can only be found a couple of times in the Qur'an. Literally, the word Sharia refers to a path or a straight path to a desirable destination. In practice, the Sharia was considered an ethical path that Muslims were obliged to follow by submitting to the will of God. But over the course of several centuries after the Prophet's death, it became a body of law as well. This body of law is expected to guide the Muslim on this ethical path. The body of law contained in the Sharia was developed from God's revelation, that is, from the Qur'an, and also the traditions of the Prophet, in other words, the Sunnah. You might be wondering why it was necessary to develop this body of law. Well, while the Prophet was alive, he communicated God's revelation or messages in a way that was relevant and applicable to the context he and the early Muslim community were living in. The Prophet was there to guide the Muslim community. So the Prophet's advice, instructions, commandments, as well as those of the Quran, provided the necessary guidance for the Muslims at the time. With the Prophet's death and the cessation of the Quran, these two sources of guidance came to an end. Equally, it is important to say that after the Prophet's death, the political, economic, social context began to change significantly for Muslims. For example, the Muslim community and the Muslim state grew and expanded significantly after the Prophet's death, immediately after the Prophet's death. Muslims in large numbers moved out of Mecca and Medina and Arabia in general and took over the two dominant powers at the time, that is, much of the Byzantine Empire and the entire Sassanid Empire. Both of them largely came under the control of the Muslims. So, within a few decades after the Prophet's death, the small Muslim community based originally in Mecca and Medina during the Prophet's time was now governing what we call today the Middle East and North Africa. Imagine how different the context would have been for Muslims in this new environment. So, we could say that this new context meant that Muslims were facing a whole lot of new issues, concerns that were not directly or explicitly covered by the revelation in Mecca or Medina. These issues would have been about, for example, governance, managing a huge state, developing new institutions for managing the economic affairs of this community, as well as issues related to Muslim and non Muslim relations, to dealing with new cultural and social issues in this very expanded community. This would have meant that new ideas had to be developed to extend the instructions and guidance provided in the Quran and in the traditions of the Prophet to apply to the new context and circumstances. Some Muslims began to specialize in developing rules and regulations and laws from the Quran and the Sunnah. Some began to think about rules and ideas for interpreting the Quran and the Sunnah. Over time, that is, over the course of roughly 200 years after the death of the Prophet, A large body of rulings and laws were developed and systematized to guide the Muslim community. This body of rules and laws covered matters related to rituals and worship, rules and regulations to manage the public and private aspects of life of the individual and the community, as well as a vast array of ethical and moral norms. So basically, the term Sharia came to encompass both the moral and ethical elements of following God's path as well as legal aspects. The key point is that Sharia is not just about law or black letter law, it covers a lot more. Today, the word Sharia usually refers to the ethical, legal, and religious code followed by Muslims. However, some Muslims interpret the term Sharia even more broadly. They believe that it refers not only to the moral, ethical, and legal code set down in the early centuries of Islam, but to any law that promotes justice and social welfare and is therefore is consistent with the overall objectives of the Sharia and Islam in general. So, what does the Sharia consist of? Well, Sharia is a very broad concept. It consists of rules, regulations, and laws that cover religious duties and most areas of everyday life. Some parts of the Sharia are quite similar to what we call law in other legal systems. For example, Australian law. But other parts of the Sharia cover areas of life that most other legal systems are not interested in or do not regulate. For example, how to perform daily prayer, or relationships with other people, or aspects of a person's private life. In all aspects of life the Sharia addresses, its overriding principle seems to be justice. Justice is its main objective, as Muslim scholars often argue. So, Sharia and justice go together for most Muslim scholars. But what type of issues or areas does the Sharia cover? Well, the Sharia can be broken down into several different areas or categories. The first consists of those rules that regulate a Muslim's relationship with God. An individual's relationship with God is demonstrated by things like acts of worship, devotion, or piety that are carried out either individually or in community with others. The part of the Sharia that covers these kinds of issues and practices is called, in Arabic, ibadat. It contains rules and regulations about things like prayer, fasting, pilgrimage to Mecca, and zakat, Z-A-K-A-T. It also includes the Islamic affirmation of faith, or in Arabic, the Shahada, that states that Muslim believes in the oneness of God and the Prophet Muhammad as the messenger of God. So that is the basic affirmation of faith in Islam. The second area that Sharia governs or covers are those transactions that human beings carry out with each other. And this is often called in Arabic mu'amalat, meaning transactions. This category contains things like contracts, civil actions, domestic issues that affect inheritance and marriage, and other civil issues such as buying and selling, lending and borrowing, and so forth. Many of the issues covered under this area are those that may be brought before a court of law. Of course, Sharia also includes criminal law. Criminal law is perhaps one of the most well known or controversial areas associated with the term Sharia these days. Most people today would have heard of what is in Arabic called hudud crimes. These are crimes that carry a penalty that is explicitly set down or prescribed in the Qur'an or the Sunnah. There are debates among Muslims today about whether these prescribed penalties or punishments can be changed, or whether they should always be a permanent feature of Islamic criminal law, even if they are not necessarily implemented, as it is the case today in most Muslim majority states. Let us look at the Islamic criminal law very briefly. So, what are the kinds of crimes that are called hudud crimes? It is just one aspect of Islamic criminal law. There is some disagreement about which crimes fall under the category of hudud, but generally speaking, the list includes things like theft, highway robbery, drinking alcohol, sex outside marriage or fornication, and unsubstantiated accusation of fornication. Some jurists include what is called apostasy or ridda in Arabic, which is about leaving Islam for another religion, or in other words, converting to another religion in this list. As I said, these crimes have specified or prescribed punishments, which may include the death penalty, flogging, or amputation. For example, the Qur'an specifies amputation of hand for the crime of theft or stealing. Muslim jurists, or those who specialized in Islamic legal matters, were very aware from the very beginning of the harsh nature of these punishments, such as amputation or flogging. They developed detailed rules about the kinds of testimony, for example, that will be required to convict a person of the crime in a court of law. They also developed various conditions to be met before a person can be convicted and punished. These very strict conditions and rules about testimony and other related matters meant that often it would be very hard to convict a person under hudud crimes. In that sense, it was not so much about applying these penalties frequently, but was more about these penalties functioning as a warning to any Muslim of the possible penalties or harsh penalties that await them if they commit any of these crimes. Its value was in possible deterrence, at least largely it was about this possible deterrence. In many cases, the criteria that must be met for the prescribed punishment to be carried out was so stringent that it was nearly impossible, in many cases, to convict and punish anyone, except rarely under the hudud laws. In summary, the Sharia encompasses all these areas and relationships. Muslims are obliged to adhere to the Sharia, but it must be continuously interpreted according to circumstances of the time, as many Muslim scholars would argue today. There are, of course, many other areas of the Sharia. I haven't covered all of them. I just gave some examples. New ideas are being developed in the modern period to cover, under the broad label of Sharia, issues such as protection of the environment and human rights, as well as bioethics. So, how did the Sharia develop? For most Muslims, the Sharia comes directly from God's revelations to the Prophet Muhammad in the Qur'an and from the Prophet's Sunnah, which represents the Prophet's normative behavior. Soon after the death of the Prophet, an organized system of laws and rules was needed to govern the new and growing Muslim community. As the Muslim state expanded, new issues arose, as I mentioned earlier. The conquests which expanded the Muslim dominated territories in the centuries after the Prophet's death created major changes to the community's demographics, bringing people into the state from different cultures, religions, and traditions. All of these major changes brought new issues and challenges to be resolved. However, the Quran itself only contains a small number of verses that are strictly speaking legal in nature or law related in nature. Some scholars argue that less than 10% of the Quran is about legal issues or rules, regulations, and laws. So many of the new situations and issues that arose had to be resolved by applying what was covered in the Quran and in the Prophet's practice to new and emerging situations. The jurists developed an Islamic legal methodology called Usulul Fiqh to develop new laws from the Quran and the Sunnah. Usulul Fiqh is an Arabic phrase or term which can be translated as fundamentals or principles of Islamic law or Islamic jurisprudence. You can think of this as a vast array of rules for interpreting the texts of the Quran and the Sunnah. Many rules are about ways of analyzing these texts. So, what are the sources of Sharia? Or from where did Sharia rules develop or were derived? Given the importance of the Quran and the Sunnah, they are referred to as the two primary sources of the Sharia. There are two other sources that are considered secondary. The first is the consensus of the Muslim community or the Muslim scholars on a particular point of law. The idea is that if there is universal agreement or consensus among Muslims on a particular point of law, that should be considered correct and authoritative. The idea is that the entire Muslim community will not agree on an error or a mistake. Obviously, if there are disagreements among Muslims or Muslim scholars on that, universal agreement would not be possible, and therefore Muslims would be free to accept or not accept such a law or a rule. The other important secondary source is what is referred to as qiyas in Arabic. Think of qiyas as a form of reasoning that we could call analogical reasoning. This is a very important tool in Islamic law or in the Sharia. It is about looking for precedents for new problems or issues. If a new problem or issue emerged in the modern period, for example, for which there is no specific rule or law in the Quran or in the Sunnah, we can look for similar cases or precedents. For example, the Quran prohibits consumption of alcohol or wine. This prohibition in the Quran is a precedent. In the modern period, we have various types of drugs about which the Quran says nothing. So, how does a Muslim jurist deal with these types of drugs? Is it okay to consume them as they are not specifically mentioned in the Quran or in the Sunnah? Here, the Muslim jurist looks for a precedent. In this case, the jurist may want to look at the case of prohibition of wine or alcohol and the effect of consumption of wine or alcohol on one's mind, as well as the effect of consumption of taking, say, drug X on one's mind. And if the effect of taking this drug X is similar to the effect of consuming alcohol that is on one's mind, the Muslim jurist may extend the ruling given to the consumption of wine to the consumption of drug X based on analogical reasoning or qiyas. One could say that a vast array of rules and regulations and laws developed in the Sharia, particularly in relation to legal matters, are based on some form of analogical reasoning. So there is a significant body of laws in the Sharia that are based on human reason. Now let us look at briefly at the schools of law or mazhabs. Over time, in the first 2 to 3 centuries of Islam, in different parts of the Muslim state, there emerged different schools of law, or in Arabic, madhabs. Madhab is an Arabic word meaning, in this case, school of law. Each of these schools of law was named after an eminent jurist. The main Sunni schools of law are the Hanafi, Hanbali, Maliki, and Shafi schools. These schools are named after important jurists such as Abu Hanifa, Hanafi school, Ahmad bin Hanbal, Hanbali school, Muhammad ibn Idris al-Shafi'i, the Shafi'i school, and Malik ibn Anas, the Maliki school. The Shia have their own school of law, which is called Jafari school. These legal schools, or mazhabs, emerged in the major cities of the then Islamic world, such as Medina, Kufa, Baghdad, and Cairo. Over time, their influence came to be distributed geographically across the Muslim world, so that each mazhab dominated one particular region. The Malikis dominated North and West Africa to Upper Egypt. The Shafis dominated parts of the central Middle East, including Lower Egypt, Syria, and along the coasts of the Indian Ocean from East Africa over the Arabian Peninsula to Southeast Asia, for example, Indonesia, Malaysia, Brunei, and so forth. And the Hanafis dominated mostly in the north, in the areas governed by the Turks and Mongols, that is, largely in Central Asia, the Mughal India, and Turkey. The Hanbalis, the fourth and smallest of the schools, was mostly present as a minority in some of the cities of the central Middle East, but it came to dominate parts of the Arabian Peninsula. The main Shia school, which is the Jafari school, developed in Medina and Kufa, but can mainly be found today in Iran, Iraq, and Lebanon. Each mazhab or school of law had its own slightly different methodology for interpretation of the Qur'an and the Sunnah, and there were often disagreements between the jurists of the different schools and even jurists within the same school. However, the work of these jurists created a huge body of ideas, interpretations, rules, and laws that traditionally has been held to be part of the Sharia. The Sharia as a set of rules, regulations, and law therefore evolved and developed over the early centuries, and it continues to develop in the modern period. So, what does Sharia as law look like? Sharia as law was not codified in any fixed form, as it is in many legal systems today. There was no written legislation from the mazhabs or the schools of law. Instead, the laws came in the form of scholarly literature and through the efforts of jurists to extract rulings from it, from this literature. Sharia as law, or Sharia law as some would call it, is often called a jurist's law for this reason. The views and statements of the early founders of the schools of law were collected in basic works, either composed by them directly or by their closest students. These were then commented upon and expanded through commentaries. The commentaries aimed to explain the views stated by the founders and, if necessary, to defend them against criticism. But they could also be used by later scholars to introduce new understandings and points of view by explaining a statement from the early founders. This literature, or juristic literature, or fiqh literature, has been expanding. In the modern period, a lot of new ideas and rulings are being produced as part of this literature. Let us now look at the question of how is the Sharia as law implemented today. First, let us look at the Muslim majority countries. So, the Sharia as law remains influential in Muslims' lives today, but how is it implemented in practice? Muslim majority countries are often perceived as countries that implement the Sharia as law. But in reality, that this is only partly true. There are, of course, 57 or so Muslim majority countries in the world. Particularly through the influence of colonialism, most Muslim majority countries have adopted legal institutions that are very similar to those that operate in Western countries. These Muslim majority countries rely on formal written codes of law, often influenced by the legislations of former colonizing powers such as Great Britain, or France. So how is Sharia applied, as law applied? There are a couple of ways in which Sharia as law is still present in the legal systems of most Muslim majority states. First, some aspects of Sharia as law have been incorporated into the formal legislation of Muslim majority countries. It is quite common to find personal law or family law provisions from the legal schools or mazhabs in a Muslim majority country's legal system. For example, Pakistan, which follows the Hanafi school of law, enacted the Muslim Family Laws Ordinance of 1961, which draws on many aspects of traditional Hanafi law, such as a man's right to divorce his wife through the procedure of what is called talaq, Talaq. Talaq is the Arabic word for divorce. It also covers a wife's right to maintenance from her husband after a divorce. During the 20th century, some Muslim thinkers have argued that the laws in Muslim majority countries should be determined by the Sharia. These thinkers also argue for Islamizing laws in Muslim majority countries, for example, by removing laws that were influenced by or based on former colonial powers, their legal systems and laws, and instead introducing laws that are based on Sharia. For these Muslim thinkers, Sharia should be the main source of contemporary Muslim law in Muslim majority countries. Sayyid Qutb and Maududi, two prominent Muslim thinkers of the 20th century, also called for the implementation of Sharia as law by the state, or what some call Sharia law by the state. For these thinkers, any law which contradicts Sharia should be discarded. However, not all Muslims agree with this position. What we call reformist scholars, in contrast, see Sharia as law is largely the human interpretation of the primary sources of Islam, that is, the Qur'an and the Sunnah. Let me quote from Abdullahi an-Naim, one such scholar or reformist scholar, and he says, and I quote, "What came to be known among Muslims as Sharia was the product of a very slow, gradual, and spontaneous process of interpretation of the Quran and the collection, verification, and interpretation of Sunnah during the 7th to the 9th centuries, that is, the first 3 centuries of Islam." End of the quote. Since for such reformist scholars, the Sharia as law is largely a product of human reason, these scholars reject the idea that the Sharia as law needs to be implemented by the state today, by a Muslim majority state today. Since Sharia has historically been, according to them, the human interpretation of the fundamental sources of Islam, Abdullah an-Naim concludes that alternative human interpretations are possible today. This is, of course, a hotly debated issue today between those Muslims who argue for Islamization of law in Muslim majority states and those who are against such Islamization. It is worth noting at this point that Sharia as law usually only applies to Muslims in a Muslim majority state. Most Muslim countries with Christian or Jewish or other minorities allow these communities to maintain certain areas of law to be governed by the laws of their religious traditions, such as family law. This is either codified as legislation by the state or more usually left to each religious community to define. It is less common to find criminal law provisions such as the hudud crimes in the legislation of Muslim majority countries today, although some countries do continue to implement them. Saudi Arabia, Iran, Pakistan, and Brunei, for example, and some parts of Indonesia and Nigeria are examples of countries where traditional Islamic law or Sharia-based criminal law in various forms are applied today. Another way of implementing certain aspects of Sharia as law is in Muslim majority countries, which is really through the Sharia courts. Some Muslim majority countries today, for example Malaysia, have a separate court system called Sharia courts that apply some aspects of Sharia based law. Malaysia's Sharia courts, for example, apply Sharia based family law and laws about religious observance. The vast majority of legal issues in Malaysia are dealt with by its common law system, which was influenced by the legacy of British colonialism in the country. Another issue of interest in relation to Sharia is who defines and applies Sharia as law. In the past, Sharia-based law was a jurist's law. This law was studied, expanded, and applied by various Muslim jurists who, at least theoretically, worked autonomously, that is, autonomously from the state. The state, of course, benefited from the work of these jurists and often applied the law through the court system. Today, however, the situation is different, as aspects of the Sharia have become codified in a similar way to legislation in non-Muslim majority countries. Sharia as law has come under the authority of the state. The state, as the legislator, now has the opportunity to influence the content of the law and to determine the appropriate penalties. This is the way many modern Muslim states have introduced amendments and modernizations to Sharia-based family law, for example, to keep the law with modern norms and values and expectations. This means that Sharia as law has continued to evolve, and Muslim majority states may have their own national Sharia law that differs from the Sharia law of other states, and also from the traditional mazhabs that developed in the early stages of the development of Sharia-based law. Let us now look at the calls for reforms of Sharia as law in the modern period. We'll look at some examples. This leads me to the issue of reform. In the modern period, a number of Muslim scholars have called for reforms to certain aspects of Sharia as law. Let us look at some examples. The first example is the issue of polygamy. We can talk about traditionalists and reformists. Traditionalists are those who want to maintain laws that were developed and maintained for much of Islamic history. They want to maintain the tradition. Reformists are interested in changing or reforming many of those laws. From the perspective of traditionalist scholars, a man can take up to 4 wives and divorce any of them at will without having to show cause. However, there are reformist scholars today who call for this to be changed. One of the key Muslim scholars of the modern period to call for the abolishment of polygamy was Muhammad Abdu from Egypt. Abdu argued that in the context of the original revelation of the early 7th century, polygamy was allowed because many men had been killed in wars, leaving women and orphans behind without men to take care of them. They were vulnerable in society, and marriage was a way of ensuring they would be taken care of. However, since circumstances had changed in the modern period, Abdu argued that polygamy should no longer be practiced. Abdu noted that even in the original context of the revelation, polygamy was only allowed if a man could treat his wives equally, without injustice. However, this is very hard to do, as he argues. The Qur'an itself acknowledges this difficulty, and so it set this condition of justice. Abdu argued in defending his position. Even though many classical jurists argued that the Quranic condition of justice that served to limit polygamy was only a moral condition binding on the husband's conscience, Abdu and other reformists argued that it should be seen as a positive legal condition for preventing polygamy. They argued that it should be legally enforced by the courts as a way of preventing injustice today. For Abdu, monogamy is the ideal form of marriage, and a ban on polygamy is consistent with Sharia. Another debate between traditionalists and reformists has been around divorce. From the perspective of traditionalists, a man has the exclusive right to divorce his wife because under classical Islamic law, divorce can be initiated by the husband even without a reason. However, reformists have argued that women should have the right to divorce their husbands as well. Reformists have argued that divorce can be initiated by the wife and it should not require the husband's consent. This kind of change is hotly debated among Muslims today. Another area where reformists have tried to implement changes is concerning punishments or penalties associated with Islamic criminal law. For example, hudud crimes we talked about earlier. From the perspective of traditionalist scholars, laws such as punishment for theft are prescribed by the Qur'an, or laws relating to punishment for theft are prescribed by the Qur'an. This means, according to traditionalists, they are God given laws that simply cannot be changed by a judge or by the state. They must be implemented as part of the Sharia. But many reformist Muslims in the modern period have called for abolishing many of these punishments or penalties. They often use a contextualist approach, arguing that the penalty of amputation, for example, can be replaced by others like imprisonment or fines. As I explained in another lecture, reformist scholars often take a contextualist approach to the law-related verses of the Quran. Muhammad Abid al-Jabiri, a Muslim thinker of the 20th century, for example, used this approach when he called for abolishing amputation as a punishment for theft. His argument was that the emerging Muslim community of the early 7th century lived in a Bedouin context. In this social context, where people moved around with their tents and camels, another form of punishment was not possible. A person could not be imprisoned when there were no prisons or even walls in the desert. There were no authorities to guard a prisoner. But since society has evolved since then, Jabiri concludes that new forms of punishment consistent with human dignity can be developed. These punishments are not deviations from the spirit of the Quran, according to Jabiri. Again, this issue of reforming traditional Islamic criminal law is, particularly in relation to hudud crimes, is hotly debated among Muslims between traditionalists and reformists. Let me also mention three key areas of Sharia as law that reformists are keen on reforming or making changes to. Their argument is that we need to bring these laws in line with contemporary norms and values of today in areas such as equality between men and women, equality between Muslims and non-Muslims, and in general, modern human rights norms. They often argue that these changes can be seen as actually inspired by important Quranic concepts such as justice for all and preventing injustice. Examples of these areas of law include, let me mention them, laws that have a negative impact on women, laws that conflict with important modern human rights norms, laws that appear to be discriminatory to non-Muslims. So how is Sharia put into practice by Muslims in Australia? The question of applying Sharia as law in Muslim minority contexts like Australia has become a very controversial one in recent years. Some non-Muslim Australians fear that Muslims in Australia advocate the application of Sharia as law instead of secular legislation, and that Muslims are seeking to create some kind of parallel Islamic legal system that competes with the secular law of the country. Much of this concern centers around the possible implementation of controversial laws like traditional Islamic laws related to women or those traditional Islamic laws associated with the hudud crimes, with their prescribed penalties that are considered highly problematic in Australia in terms of contemporary norms. These kinds of claims often lead to sensational headlines in the media. But is this something that Muslims in places like Australia are really seeking? As I have covered earlier in the lecture, Sharia is a very broad concept that covers pretty much all aspects of life of a Muslim. It provides the basic guidelines for a Muslim to function as a Muslim individually first and foremost. A Muslim, whether he or she is in Australia or anywhere else in the world, can easily apply Sharia to his or her life easily, regardless of the legal system under which the person functions. In Australia, for example, an observant Muslim applies Sharia to his or her life. Australian law does not prevent a Muslim from doing so. It is free under Australian law for anyone to follow any religion, to worship in any way one wants, to believe or not to believe in God or any religion, and to make personal choices in a wide range of areas of daily life. This means there is a lot of freedom for individuals under Australian law to be whatever they want to be as far as religious beliefs, traditions, and practices are concerned. This allows a Muslim to be a Muslim, to follow the fundamental practices of Islam, such as the daily prayers, fasting in the month of Ramadan, paying zakat, performing pilgrimage to Mecca, and many other similar practices. This also allows Muslims to establish places of prayer, teach about Islam to children and others, and organize activities or religious activities in public. There are certain things a Muslim should not do according to the Sharia. For example, the Sharia prohibits a Muslim from engaging in things like theft, sex outside marriage, drinking alcohol or wine, gambling, and the like. An observant Muslim can follow Sharia in these areas relatively easily in Australia. It is about the choice a person makes. Even though certain things are permissible under Australian law, such as consumption of wine, eating pig meat, and gambling, for example, there is no Australian law that forces a Muslim to consume wine or eating pig meat or to eat pig meat or to go to a casino and gamble. Under Australian law, a Muslim can easily make the choice not to consume wine or not to gamble. So, by and large, what the Sharia requires a Muslim to follow can easily be followed in Australia. Even when there is some tension between certain aspects of Sharia and Australian law, in Australia most Muslims have, to varying degrees, developed different strategies to ensure they are compliant with the Sharia and Australian law at the same time. Muslims for more than a century have worked, studied, raised families, worshipped, and lived their lives in accordance with the basic tenets of Islam or Sharia, while also adhering to the Australian law. The task of navigating through Sharia and Australian law has not caused many difficulties for most Muslims. The key point to remember is that Muslims follow the system of law that exists in Australia. Laws that exist at the Commonwealth, state, and local levels are those laws that Muslims also follow and adhere to. Following these laws is thus not seen as an issue at all for the vast majority of Muslims. Just like other citizens, Muslims do not see a problem in abiding by them. In general, many Muslim scholars would argue today that the Sharia expects Muslims to abide by the system of law that exists in the country where they live or reside. Where Muslims find it somewhat challenging to follow Sharia in the Australian context, they often find ways of managing that. It is a way of finding a solution to those challenging areas. Let me give some examples. First, marriage and divorce. Just like people of many other religious traditions, marriage and divorce are closely related to religion for most Muslims. As far as marriage is concerned, Australian law is flexible enough to accommodate the basic requirements for marriage from a Sharia perspective. The Marriage Act 1961, Commonwealth, accommodates Islamic marriages by allowing marriages to be performed and registered by a Muslim marriage celebrant, usually an imam, without the need for a separate registering event or ceremony. The requirements of the Australian law do not contradict the requirements of the Sharia as far as marriage is concerned. This way, the marriage meets both the Islamic religious requirements of the Sharia and Australian legal requirements. The Sharia requirements for divorce can be somewhat different to that of Australian family law. In this case, Muslims, like other citizens, go through the normal legal processes for divorce. But there are certain aspects of divorce that can still be problematic, particularly for women. Another issue that is related to Sharia is the prohibition of riba. Riba is an Arabic word which is mentioned in the Qur'an, and it is prohibited in the Qur'an. A lot of Muslims understand riba as equivalent to modern interest. A Muslim is expected not to deal with riba, not to engage with riba. In Australia, all financial institutions and borrowing and lending are generally based on interest. For observant Muslims who believe that riba is interest, borrowing money from the bank or for buying a car or a house can be somewhat challenging. Even here, these Muslims find ways of working with existing systems. The Sharia provides guidelines for this as well. One of the principles of the Sharia as law is that where a necessity, or in Arabic, darura, D-A-R-U-R-A, exists, things that are ordinarily prohibited under the Sharia can be temporarily permitted. For example, buying a house to live in Australia is considered a necessity. Similarly, buying a car to move around is considered a necessity. Therefore, for those Muslims who believe interest is equivalent to riba, it is still permissible to buy a car or a house while borrowing funds on an interest-paying basis as a temporary arrangement. There are also financial institutions in Australia that are called Islamic financial institutions that try to stay away from interest and try to do their business without interest. But such institutions are still relatively few and small in scale, and therefore the vast majority of Muslims engage with financial institutions based on interest. This is a question that has emerged in Australia recently. That is, should Australia formally recognize religious law of various ethnic communities? In Australia, both sides of government have expressly said that Australia's legal system will not recognize a separate stream of religious law for religious or ethnic communities, including Muslims, because of its commitment to secularism. However, given that Muslim Australians are already regulating their lives according to the Sharia in a wide range of areas, and the Sharia provides guidelines for Muslims to function under the legal systems that are not necessarily based on Islam, we are not hearing calls from Muslims for a formal recognition of Sharia in Australia. It is not a debate the vast majority of Muslims are engaged in. For Muslims in general, when they live in a country that is not predominantly Muslim and does not apply Islamic law or Sharia-based law as part of the legal system, they are expected to abide by the legal system of the country while attempting to apply Sharia norms, guidelines, and rules as much as possible. So, in summary, the Sharia is the legal, moral, and religious code followed by all Muslims or all observant Muslims. It evolved during the early years of Islam. Many Muslims believe it should continue to evolve as Muslims face new legal and moral contexts in the modern world and as circumstances change from the time of the original revelation of the early 7th century. For Muslims, the Sharia is all encompassing. It engages with many aspects of their day-to-day lives, more so than any secular legal system. Although Sharia as law can be at times in tension with some of the secular laws that exist in a country, by and large there are mechanisms in the Sharia that provide space for Muslims to function comfortably under a secular legal system while remaining as observant and practicing Muslims. Thanks for watching. We hope this deepened your understanding of Islam. Be sure to check out the other videos in this series. Keep exploring. Don't forget to subscribe.